This is a debrief of Task 1 from AAT's sample assessment for credit and debt management. So this task is about law and ethical principles. There's a lot of theory involved here, so you need a lot to remember. So in part A, identify which of the following statements regarding consideration are correct. Remember, consideration is the term that we use for describing what the two parties are going to transfer to each other according to the contract. So first of all, it must be sufficient and adequate. So what does sufficient mean? Sufficient means that it has some sort of value. And then adequate is about how much that value is. So for example, I might enter into a contract with you to buy, say, your house for £1. Would that be okay? Well, £1 is sufficient because it has a value. Is £1 adequate for your house? Well, no, it isn't. But according to contract law, it doesn't have to be adequate. It's okay for you to get a bargain on your contract. Contracts don't have to be necessarily fair for both sides. And it could be that someone is happy to take £1 for other reasons which are not commercial. So number 1 is not correct. It's not one of the correct answers because contracts need to have consideration that is sufficient, but adequacy is not a requirement. And then the second statement, it must not happen before the promise. And that's correct. The consideration needs to happen after the promise. So that means the answer is the second one. Part 2 only is the correct one here. Let's have a look at the next one. Lily goes into a shop to purchase a new laptop with a price on the label stating the product to be £250. She takes it to the cashier who scans it and states that the price is in fact £350 and that the price on the label was misprinted. Lily insists that the shop has to sell it to her for £250. Well, that's not correct. So part B says, identify which of the following is the correct term for the price displayed on the price label of the laptop. So when you go into a shop and you see the goods on display there and the prices on the goods, that is an invitation to treat. And then when you take the goods to the cashier and you say, look, I want to buy this, that is you making an offer to the shop. And then they can decide whether or not they want to accept the offer. And in this case, they say that, well, actually the price is £350 and they don't want to accept Lily's offer of buying it for £250. So Lily can't insist that they sell it for £250 because Lily is the one making the offer in this case. They're saying, look, you've advertised it for £250. I'm willing to offer that. And then the shop decides, well, actually, no, we're not going to accept this. So in this case, the price label is the invitation to treat. It's inviting the customers to make an offer to the cashier. We're moving on to part C. Identify whether the following statements are true or false. The intention to create legal relations is in a contract means the agreement can be enforced in a court of law if necessary. So this is one of the underlying assumptions in a contract, that the two parties intend to create a legal relationship with each other. So normally this is pretty obvious, but it's not always. But this is true that we need to have that intention to create the legal relations, and then it can be enforced in law. So the assumptions for this intention, we should assume that social, domestic and family arrangements are not intended to be legally binding, but we also assume that commercial arrangements do have that intention. So in this case, we're talking about social arrangements, so that's false. There is no assumption that social arrangements have that intention to create a legal relationship, because it's just friends agreeing to do things for each other, but they're not necessarily promising to do that, and there's no expectation that we're going to take each other to court if we don't. Moving on to part D, identify whether the statements given below relating to a contract are correct. So a contract can be made voidable due to one party being classed as a minor. We need to differentiate between these two legal terms of being void and voidable. So something that is void, a contract that is void, isn't actually a contract. So the parties do not need to follow the terms, and any consideration transferred may be recovered. So a contract is void if, as you can see on the screen, the parties alleged that they were mistaken in some way, if any of the terms in the contract are simply illegal, or if the terms are contrary to public policy. So for example, a company sells something to a customer for a very high price. The company is a monopoly, and monopolies can take advantage of their position by charging high prices, and this would be contrary to the public policy on fair competition. So in this case, someone could go to the court and say, I don't think this contract is fair, and it would be considered void because it doesn't meet public policy. In contrast, a voidable contract is a valid one, but it can be set aside by one of the parties. So it could be, as you can see on the screen, that one of the parties has a lack of capacity. So they must be of sound mind and be at least 18 years old. And that's the case in this case, isn't it? Because we've got a minor. So because we have a minor, that person could say, look, I'm not really old enough to understand this contract, and therefore I want this contract to be set aside. So yes, that's correct. That would be voidable. Other conditions would be that there's a lack of free will, so a party must not agree to a contract by force, by duress or undue influence. So that's not relevant to this particular case, but it's just part of our revision. And then also if there's misrepresentation, so if one of the parties just lies to the other party, then they can say that I don't really want to follow this contract, and the courts could set it aside. The second statement, a breach of a warranty term in a contract is usually seen as more important than a breach of a condition term. Well, no, that's not the case. Okay, it doesn't really matter what type of term it is. If we've breached the terms of the contract, then we've breached the terms of the contract. So let's move on then. So we're looking here at a particular piece of legislation. We're looking at the Late Payment of Commercial Debts Interest Act. So we're told that a customer owes £5,000 excluding VAT at 20%, and the debt is 45 days overdue. The current base rate is 0.5%. So we need to calculate the following: the percentage rate used to calculate the statutory interest charge for the amount overdue under the Act. So the way we're going to do this, the law says that we need to take 8% and then add on whatever the base rate is, which is 0.5% in this case. So our answer is 8.5%. The next part, what would be the interest charge to the nearest penny? So we've provided the formula there for you, which we need to be able to remember for the exam. So it's going to be the amount including VAT, so it's going to be the £5,000, but we multiply by 120% to include the VAT. And then we multiply by the base rate plus 8%, so we multiply by the 8.5%, and then we need to time apportion it. So we need to multiply by the 45 days that is overdue divided by the 365 days that we have in a year. And once we do that, we get £62.88. And then the law also allows for a fixed compensation amount, and we can claim this in addition for recovering the debt, because we've got to have the cost of chasing them. So this is a fixed £70. And then for the last two parts of the question, identify whether the following statements related to the data protection legislation are true or false. So the Data Protection Act gives protection for information related to living individuals. So yeah, that's true. Yeah, we're focusing on the data subjects, whether that's the terminology in the legislation, who are individual living people. Second statement, the Data Protection Act gives protection to information related to limited companies. No, that's not the case. Okay, so limited companies are not protected under the law. then individuals can request that data related to them will not be used for direct marketing purposes. So yeah, that's true. So there's a variety of rights for individuals. They have the right to inspect the data, they have the right to make the data corrected, they have the right to have the data deleted, but yes, they can also say, look, I don't want my data to be used for marketing. And part G, identify the correct option for each statement related to the Consumer Rights Act. So the Consumer Rights Act states that a buyer of goods should expect that the goods to be, so we have a choice of three things, of excellent quality. Well, no, that's not the case. We don't need to have excellent quality. It just needs to be good enough for what we want it. So yeah, so of satisfactory quality. So yes, that is correct. So either of the remaining two answers could be true. Fit for use or fit for purpose. Okay, well, it needs to be fit for purpose as described. Yeah. So it doesn't necessarily need to be fit for use, but it needs to be fit for the purpose we've described. So for example, if you go into a sports shop and you see some tennis rackets and you explain to the customer service people there that you want to use those tennis rackets as snowshoes, for example, and they look at you oddly and they say, well, okay, if you want to, and they sell those tennis rackets to you, and you go to somewhere snowy and you put the tennis rackets on your feet and they break, then you could legitimately take those back to the shop and get a refund because you said, look, I want to use these as snowshoes, and they didn't work. So they were not fit for purpose as described, and therefore you could get your refund. So the next part then, the remedies that exist for a customer under the Consumer Rights Act are, well, we are entitled, if we buy something and they're not good enough, then we are entitled to get a refund for those. So either the first or the third could be correct. Or instead of a refund, we could have them replaced, but notice all three answers say replace. So then we need to decide either repair or recycle. Well, we are entitled to have our item repaired if it doesn't meet the satisfactory quality. So it's the first answer in our choice here. And then the time period for the consumer to not have to prove the fault existed at the time of purchase, well, we have up to 6 months to be able to do that.